Silence, no more plea. We the people, we shall be.
Good evening. So my name is Cant Downing. I'm the civil rights litigator that Ms. Saxon was just talking about. I need to step up here and just provide a little bit of clarification so we can understand what just happened, what was said, and what we're actually asking from all of you, because I think that's pretty important here. So I have approximately 22,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from here within the state of Minnesota. Many are from within this area itself. Now, again, no state can create its own alternative legislation, substitute that for the guarantees of the Constitution, then go out and enforce it as though that's constitutional. That would be very unconstitutional. I think we can all agree with that. So if your police are choosing to rely upon an inferior state statute that permits them or directs them to go out and charge by way of information for an infamous or capital crime, then that would be illegal. It would be a crime itself. So these affidavits, they identify two particular crimes. The first crime is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation deprives any person of any right secured by the Constitution commits that crime. Now, the second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that statute says is that when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now, the laws of criminal conspiracy with regard to public officials, what that states is that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined to dispense the action. So upon having been provided with this notice, letting you know that your agents whom you pay are going out and violating the Constitution of the United States of America, I would ask that you guys work with us, please, to fix this. We're not trying to get anybody into trouble. That's not what this is about. We're not even trying to get the police into trouble. But we are saying that if we can't get resolution to this issue very, very quickly and very, very soon, then we're going to have to do this in a much more public and messy manner. And I don't want to have to do that. So please don't make me have to. Now, I know that you're going to go in here and you're going to ask the attorney as soon as we're done whether or not what I'm saying is true. That attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 of the Constitution says all legislative power is vested in Congress of the United States. So I pray that you guys will make the right decision here. I know that this is a very difficult decision that you're going to have to make, right? You're going to have to decide whether or not you're going to obey a judge-made ruling or the supreme law of the land, the Constitution of the United States of America, the object of which your fidelity is bound. But I'm going to pray that you guys make the right decision. Now, I want to end you with this, though, because I want to entice you a little bit to make the right decision here. The United States Circuit Court has identified an abuse of discretion. All right, there's a two-part test to determine abuse of discretion. The second part states that any erroneous view of the law is an automatic abuse of discretion. And let me tell you that an erroneous view of the law will be that in your legal contemplation, that the lowest form of law, a judge-made ruling, is in legal contemplation superior to the Constitution of the United States of America. That would be an obvious erroneous view of the law. Therefore, according to the United States Circuit Court, if you continue to pay these public officials to commit these crimes, that will be an abuse of discretion by their very definition. So thank you guys so much. God bless. Have a great rest of your day.
Silence, no more plea. We the people, we shall be.